Before we start, I need to clear the air because a lot of people online are mixing two different stories and turning it into panic content. You've probably seen the headlines, Supreme Court just destroyed the Second Amendment, or 8-1 ruling means your guns can be taken any time, and some even throw in, and now they're coming for your free speech too. That sounds dramatic. It gets clicks, and it spreads fast, but it's not the truth. The real Supreme Court case behind the 8-1 decision is United States versus Rahimi. And what the court actually said is more narrow, more legal, and honestly more practical than the fear-based versions you're seeing. The court did not end the Second Amendment. The court did not say the government can disarm anyone just because someone accuses them of something. What the court did say, in simple terms, is this. If a court has already found, through a legal process, that a person is a credible threat to another person's physical safety, then temporarily disarming that person can fit within the Constitution. In Rahimi, the question was about people under a specific kind of domestic violence restraining order, and the court upheld a federal law that restricts firearm possession in that limited situation. Source. That's the core message. People are presenting it like a total rewrite of gun rights, but it's really a clarification about how the Bruin history and tradition test works, and how courts should compare modern laws to historical analogs without demanding an exact copy of an old law from the 1700s. The court specifically rejected the idea that the government must find a perfect historical twin for every modern regulation. It's more about principles and analogies. Source. Now, where does the First Amendment come in? Here's the issue. Rahimi is not a First Amendment case. It's about the Second Amendment and a federal statute. But at the same time, there are separate First Amendment fights happening in the Supreme Court world about government pressure, censorship by proxy, and officials leaning on private companies to choke speech or groups they dislike. Two big examples people point to are NRA v. Vullo, about alleged pressure on regulated financial and insurance entities, and Murphy v. Missouri, about government contacts with social media platforms. Those are separate tracks. When content creators blend these cases together like they are one master plan, it confuses the public and makes people make stupid decisions in real life. Source. So today, I'm going to explain what the 8-1 decision actually was, what it was not, how it affects gun owners in real life, and why you should be careful about internet legal advice. Because the biggest danger is not just politics. The biggest danger is you believing a viral clip, missing a hearing, sending a hot-headed message, and walking straight into a legal disaster. Let's start with the basics. What was the case about? United States versus Rahimi involved a federal law, 18 U.S.C., paragraph 922G, 8. This law makes it illegal for a person to have a gun if they are under a certain type of domestic violence restraining order. Not every restraining order qualifies. The law requires specific conditions, including that the person had notice and a hearing, and that the order includes certain findings, like a finding that the person represents a credible threat to the physical safety of an intimate partner or child, or certain explicit restrictions. The key phrase you keep hearing is credible threat. The Supreme Court focused heavily on that concept. Source. And the Supreme Court's main conclusion was basically, America has a historical tradition of firearm regulation that allows disarming individuals who pose a credible threat to OT/HER's physical safety, and this law fits within that tradition when applied to someone with that kind of court finding. Source. Notice, the words I'm repeating, court finding, credible threat, temporary, due process. This is not someone tweeted, you're dangerous, so you lose your rights. It's a court, using a legal process, has determined something specific, and that can trigger a limited restriction. Now let me say what the court did not say, because this is where the internet lies the hardest. The court did not say the Second Amendment is over. The court did not say every accused person will be disarmed. The court did not say the government can just label you a threat and take your guns. The ruling was narrow, tied to a specific statute, and a specific kind of restraining order with specific legal safeguards. Source. Here's why the Second Amendment is dead narrative spreads anyway. Because it's emotionally effective. It makes people angry. It makes people share. It makes people feel like they're getting urgent truth. But it also makes people careless. And careless is expensive in court. Now let's talk about the Bruin test, because that's the part many people don't understand. And Rahimi matters here. In 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruen. Bruen set a text, history, and tradition approach. Instead of using balancing tests like, is the law reasonable? Courts should ask whether the modern gun regulation is consistent with the nation's historical tradition of firearm regulation. That created confusion in lower courts. How close does history have to match? Do you need an exact old law? What if the modern problem didn't exist in 1791 in the same form? Source. In Rahimi, the Supreme Court clarified that you do not need a perfect historical twin. You need a historical analog. In other words, the modern law should be comparable in why it exists and how it burdens the right. The court even emphasized that why and how the regulation burdens the right are central to the inquiry. This is a big deal because it tells lower courts not to treat Bruin like a rigid scavenger hunt where you must find an identical statute from the founding era. Source. That part is important because some people online were celebrating the Fifth Circuit decision that struck the law down earlier, thinking it meant lots of gun laws would fall. The Supreme Court reversed that. It didn't abandon Bruin, but it controlled how Bruin should be applied so it doesn't become absurd. Now, what about the First Amendment angle? This is where people mix stories for drama. Rahimi is Second Amendment, but there are separate First Amendment cases and controversies about government influence. In NRA v. Volo, the Supreme Court unanimously held that the NRA plausibly alleged a First Amendment violation based on claims that a state official used regulatory power to pressure or coerce third parties to cut ties with the NRA. The key idea is that government cannot use threats of enforcement or regulatory pressure to punish or suppress protected speech indirectly. That is not Rahimi, but it is part of the broader conversation. Rights can be attacked directly or indirectly. Source. Then you have Murphy v. Missouri, where the court ruled largely on standing grounds, saying the plaintiffs lacked Article III standing to seek an injunction, even though the case involved allegations that government officials pressured platforms regarding content moderation. Again, separate case, separate legal questions, but it shows why indirect pressure is a live issue in First Amendment law. Source. So the honest way to explain it is, Rahimi clarifies a Second Amendment framework for disarming people found to be credible threats via court process. Meanwhile, separate First Amendment disputes involve whether government officials can pressure private entities to suppress speech. If you mash them together into one headline, you can say both amendments changed today, but that's misleading. And I'm telling you right now, misleading legal info is not just annoying. It can set people up for real consequences. Here's how. Most gun owners don't lose rights because of some dramatic SWAT moment. A lot of them get in trouble because of paperwork and procedure. They ignore a court date. They don't take a restraining order seriously. They think it's civil, not criminal, so it's not a big deal. Or they believe someone online who says they can't do that, it's unconstitutional. And then they keep possessing firearms while under a qualifying order. That can turn into a federal charge. It can turn into a felony. And it can turn into a permanent loss of rights, even if the original situation was temporary. And if you're not a gun owner, you should still care about clarity, because the same kind of misinformation machine can distort any constitutional issue and make the public impossible to educate. Now, I'm going to give you the clean version of the Rahimi holding. The court said that Section 1922G8 is constitutional as applied to Rahimi's situation because he had been found by a court to pose a credible threat, and the restriction is temporary and tied to that court order. It's basically the idea that society can restrict a person's access to weapons when a court has determined they are dangerous to someone else in a way that fits historical traditions like surety laws or laws against going armed to terrorize others. Again, narrow, focused, not a blank check. Source. Now, I want to pause here and talk to you like a normal person, not like a law textbook. If you're a stable, law-abiding person, this decision is not about you. This decision is about the line between the people, protected by the Second Amendment, and individuals a court has determined are posing a real threat right now. The internet tries to sell it as they'll come for everybody, but the decision itself is not written that way. Written that way is something else. If you're involved in a domestic situation and a court issues an order, do not treat it like a joke. Show up, respond, get counsel if you can. Because missing a hearing is one of the worst moves you can make. You can lose by default, and then the legal system will treat the findings as real, because they are real on paper. All right, before we go deeper, quick support break. If this breakdown is helpful and you want more simple, straight explanations without panic, hit like, subscribe, and share this video with someone who's been reposting those wild headlines. And tell me in the comments, do you think most people are being misled on Rahimi, or do you think the court went too far? Now, let's get practical. I'm going to break down the biggest myths, then I'll give you a short checklist of what to do and what not to do. Myth number 1, just an accusation means you lose your guns. Wrong. The law in Rahimi is about qualifying restraining orders, and the court's reasoning keeps coming back to a court process and findings. The case materials and summaries emphasize notice and a hearing, and the idea of a judicial finding of credible threat. That doesn't mean every state process is perfect, and it doesn't mean mistakes never happen, but it does mean the Supreme Court did not endorse accusation equals disarmament. Source myth number 2. The government can call anyone dangerous and take guns. Wrong as a statement of what Rahimi held. The court did not create a free-floating dangerousness power. It upheld a specific statute in a specific context, connected to historical analogs and procedural safeguards. If future laws go broader, they will be challenged under Bruin's framework and Rahimi's why-how comparison. Source myth number 3. Bruen is dead now. Also wrong. The court did not abandon Bruen. It corrected a rigid reading of Bruen. It pushed back on the Fifth Circuit's approach that treated the history test like it required an exact match. Rahimi is more like, Bruen is still the framework, but apply it with analogical reasoning, focusing on the purpose of the regulation and the burden on the right. Source. Myth number 4. This case was also about free speech. No, Rahimi itself is not, but it's happening in the same era as major First Amendment cases involving government pressure. That's why the confusion exists. People see multiple cases and combine them into one storyline. If you care about the First Amendment angle, look at NRA v. Vullo, where the court discussed the idea that officials cannot coerce private parties to suppress speech. That's a different legal fight, but it's real. Source. Now, the competitor strategy you mentioned is real. Fear hook, then explanation, then repeated subscribe CTA, then position themselves as the only trusted source. The better strategy is less fear, more clarity, and practical steps. So here are real-life risks that matter more than internet arguments. One risk is ignoring a court hearing. People think the truth will win automatically. It won't. Courts run on procedure. Miss the hearing, you might get an order entered anyway, and then you're stuck fighting uphill. Another risk is sending angry texts, DMs, or posts. People don't understand that these can be used to argue threat, harassment, or to support a restraining order. Even if you think you're just venting, your message can be read in a courtroom in the worst possible light. Another risk is relying on TikTok law. Someone will confidently say, they can't do that, and you'll want to believe it because it feels good. But feeling good doesn't protect you from a charge. And another risk is thinking temporary means harmless. Temporary restrictions can have long-term consequences. If you get arrested for possession while prohibited, that's not temporary. That can change your record permanently. Now let's zoom back to what Rahimi teaches about the legal test. The court's explanation about analogs is key. They say you don't have to find a historical twin, only an analog, and you must look at why and how the law burdens the right. That's important because it affects many future gun law cases. It gives lower courts a way to uphold certain regulations if they can connect them to historical principles of preventing violence and managing credible threats without demanding an identical old statute. Source. At the same time, it also means governments can't just pass anything and call it public safety and assume it survives. They still have to justify it within the history and tradition approach. Now I'm going to give you 5 practical takeaways, simple and usable. 1. Credible threat is a legal trigger, not just a political insult. It's not what people call you online. It's what a court finds through a process. In Rahimi, that court finding mattered. Source 2. Due process matters. Notice and hearing are not optional. If you skip them, you might lose by default, and then you'll be living under an order you didn't fight. 3. Temporary restrictions can still cause permanent damage if you violate them. The fastest way to destroy your rights is to test the system while an order is active. 4. Bruen is still alive, but it's not meant to be used like a rigid, show me the exact 1791 law or you lose game. Rahimi clarified that. Source. 5. The First Amendment battlefield is real, but keep the cases straight. Rahimi is not speech. NRA v. Vullo is a major example of the court addressing alleged coercion and the idea that government can't use informal pressure to suppress protected advocacy. Source. Now let's do a myth-busting recap because I want this to stick. If someone says just an accusation means you lose guns, tell them, no, the decision was about a qualifying restraining order with court findings and process. Source. If someone says government can disarm anyone anytime, tell them no, the court upheld a narrow application tied to credible threat findings and historical analogs. Source. If someone says Bruen is gone, tell them no. Rahimi explained how to apply Bruen without demanding a historical twin. Source. If someone says this is also the free speech case, tell them different case. Look at NRA v. Vullo for that line of issues. Source. Now, one more practical section, because I want you to be able to turn this into a strong video with a useful ending. Here's a do and don't checklist that fits your theme, what not to believe online, and rights are lost in boring paperwork. Do take any court notice seriously. Even if you think it's nonsense, you respond through the system, not outside the system. Do document calm behavior. If you're in a conflict, be the boring person. Boring wins in court. Do consult a qualified attorney in your state if you're under an order. Laws vary, procedures vary. Do not keep firearms if you are legally prohibited under an active qualifying order. Don't gamble. Do not send threatening or aggressive messages. Even if you think you're just standing up for yourself, it can be framed as intimidation. Do not rely on viral summaries for legal advice. Use them only to know what to research next. And this is also where your video can stand out. You can tell your audience, I'm not here to scare you, I'm here to keep you safe. That's a better brand long term. All right, quick second CTA, different style. If you like this kind of calm, practical breakdown, press like right now so YouTube shows it to more people who are getting misled. Subscribe if you want weekly updates on major court decisions without the fake panic. And share this with one friend who sends you those breaking clips at 2 a.m. Now let's connect the First Amendment engine idea you wrote, because it's actually a strong point when explained correctly. A lot of people say the Second Amendment is about guns, First Amendment is about speech, separate things. In real life, they connect because speech is how people organize, advocate, educate, fundraise, and fight legal battles. If speech and association get chilled through indirect pressure, that can weaken the entire ecosystem of any rights movement. That's why cases like NRA vs. Vullo matter to people who care about gun rights, even though it's a speech case. It's not about whether you like the NRA. It's about whether regulators can pressure third parties to cut off disfavored groups. The court allowed the NRA's claim to move forward because it plausibly alleged coercion, which is constitutionally sensitive. Source. But again, don't confuse that with Rahimi. Rahimi is not the court saying speech is now restricted. It's a different category. So when your title says change both First and Second Amendment rights, you can frame it like this in the script. Today I'm talking about how an 8-to-1 Second Amendment ruling is being misrepresented, and how separate First Amendment battles about indirect pressure are being blended into the same fear story. That keeps your title punchy, but your content honest. Now, I also want to address something sensitive in a responsible way. Domestic violence is a serious topic, and courts sometimes move fast because the risk is real. At the same time, due process is essential because mistakes can happen and orders can be abused. The Supreme Court's approach in Rahimi basically tries to say, when there's a credible threat finding in a legal process, the government can act to prevent harm, and history supports that kind of targeted intervention. It's not an unlimited power, but it is a recognition that rights can be temporarily restricted in narrow circumstances for safety, consistent with historical tradition. Source. Now imagine two viewers watching your video. Viewer A hears the panic version. Your rights are gone. They can take your guns any day. That viewer gets angry, shares misinformation, and may also ignore legal reality if it ever hits them. Viewer B hears your clarity version. The court upheld temporary disarmament after court findings of credible threat. Don't ignore hearings. Don't trust viral legal takes. And keep First Amendment coercion cases separate. That viewer becomes safer, smarter, and harder to manipulate. That's the kind of channel people stay subscribed to. Now, let's close with a strong summary that matches your main theme. Here's the truth in one line. The Supreme Court did not kill the Second Amendment. It clarified that the Constitution allows temporarily disarming someone who a court has found to be a credible threat. And it clarified how Bruin's history and tradition test should be applied without demanding a perfect historical twin. Source. And here's the warning. Mixing cases, spreading half-truths, and relying on internet advice can put people into serious legal trouble. Most rights aren't lost in dramatic moments. They're lost in missed hearings, ignored orders, and careless messages. One last CTA, unique style to finish. Before you leave, do 3 quick things. Tap like to support clear information, subscribe so you don't miss the next Supreme Court breakdown, and share this video in your group chat with the words, "Watch this before you panic." It might save somebody from making a life-changing mistake.